Only on CBS 46 tonight, Inside from the Inside. For weeks, we've been telling you about the uproar in Statham, Georgia. Residents there upset over what they call excessive and even false DUI arrests.
Well, last night, the police chief defended his department and their actions to us. But now a former city employee is telling a different story.
She talks only to CBS 46's Adam Murphy.
For the first time, we're hearing from an employee who worked closely with the mayor here at City Hall. She said the job was so stressful, it physically made her sick, and she always felt like something was wrong.
It was definitely a good old boy system.
Harriet Kilpatrick is not surprised to hear about the latest controversy in the city of Statham.
It was just a lot of stress.
She worked as a city clerk for about a year until being forced out in 2015.
My gut was telling me that something was wrong, but I didn't know enough about politics to be able to even speak about what that was.
More than 300 people have signed a petition calling for a criminal investigation, claiming that Officer Mark Lofton is policing for profit.
Well, I felt like the numbers were just pulled out of the air instead of based on something real.
Kilpatrick said the budget for police fines in 2014 while she was working for the city was $76,000. Today it has more than tripled to $250,000, much higher than some neighboring jurisdictions.
The Stathams were higher in every case, every case.
Police Chief Alan Johnston defended his department, saying Lofton has made 53 DUI arrests for drugs during the past year, making the community a safer place. But some argue they're being falsely charged with DUI for taking basic prescription meds.
Well, this just seems to me as one bad police officer. So why they have not addressed that yet, I do not know. I mean, I cannot imagine them not addressing that if so many people have come forward.
Many of the people who claim they were falsely arrested in this small town plan to take their fight to the district attorney's office. They'll hand deliver a petition there tomorrow demanding an investigation. In Statham, Adam Murphy, CBS 46 News.
Stinks bad. It's like a sewer. This whole thing is opening up to be the stench of a sewer.
CBS 46 uncovering new controversy in a Metro Atlanta Police Department racked with accusations of false arrests. Startling new video tonight shows a Statham police officer's wife being stopped for DUI. Her husband is the officer who's accused of making bogus arrests for drunk driving.
His wife is no longer on the hook for DUI, but others still are for charges they say are unfounded. CBS 46's Adam Murphy has been on this story from the very beginning and has the latest twist in the Statham police controversy. Adam?
Tracy, a group of concerned citizens in Statham are furious over this latest development, calling the judicial system rigged in favor of who you know.
Are you on any types of medications or anything?
Officer Mark Lofton is the talk of the town in Statham.
173 dispatch 23.
The district attorney is investigating complaints which accuse him of policing for profit.
I'm simply tired of these innocent people and these citizens' lives being ruined.
Statistics show that Lofton has made 63 DUI arrests during the past year, but some victims argue they were completely sober and falsely charged because they take prescription medication.
Why can't you do it? Calm down for me. Just take a deep breath for me. Why can you not do it?
So you can imagine why some are outraged over this. Winder police charged Lofton's wife last year with DUI.
Right, ma'am. I need to work with me. I tell you, I'm trying to help you out. Okay, blow spice for me. Blow it for me. Blow. Blow. Don't suck on it. Blow. Blow, 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 blow. Okay.
She blew a .204 on a breathalyzer test, which is more than double the legal limit. But in August of this year, her case was dismissed.
She's married to a police officer. All of a sudden, she's not going to jail and she's not getting prosecuted. But everyone else in our city and in this county is getting prosecuted for the same offenses and even less.
Now, why is that? That's all we want to know. Why? Not some legal gobbledygook. Why didn't you prosecute him?
According to the incident report, Lofton's wife admitted she should not have been driving. We tried calling her and even dropped by the gated community where she lives, but never made contact.
It smells foul. It stinks, it stinks, it stinks. I don't care what way you try to spin it. The facts are the facts are the facts.
I spoke with the district attorney about the dismissal of this case. He said the officer involved had severe credibility issues and no longer works at the Winder Police Department, and therefore many of his cases have been dropped. That same officer was honored by Mothers Against Drunk Driving 2 years ago, though, for his excellent work. Live in Statham, Adam Murphy, CBS 46 News.
Very interesting stuff. Thank you, Adam. CBS 46 began investigating this story last month. It began after we spoke with several people who told us that Officer Lofton arrested them for DUI. They all say they were not drunk. They were just taking prescribed medication. CBS 46 will continue to uncover.
Great information below shared by a friend. Zielke v. State of GA. The Supreme Court of Georgia holds that police officers have no right to make custodial arrests outside of their territorial jurisdiction. Many of Mark Lofton's false arrests were outside of city limits, and proper procedure was not followed. Georgia Supreme Court, police cannot make traffic arrests outside their jurisdictions. Atlanta, Georgia, 41 NBC/WMGT. The Georgia Supreme Court has ruled police officers across the state are no longer allowed to make traffic arrests outside their department's jurisdiction. The High Court made the unanimous decision in favor of a Kennesaw State University student. Justices say it was illegal for a campus police officer to stop him in 2013 and charge him with driving under the influence 500 yards off school property. Zielke v. the State. With an opinion today by the Georgia Supreme Court, police officers around the state may no longer make traffic arrests outside their department's jurisdiction. In today's unanimous decision, written by Justice Robert Benham, the High Court has reversed a Georgia Court of Appeals decision and ruled in favor of a man who argued that his arrest by a university police officer for driving under the influence, DUI, was invalid because it occurred more than 500 yards off campus. According to the facts of the case, in the early morning hours of May 5, 2013, Badge Roden Zielke was stopped and arrested on Powder Springs Road in Marietta by Officer Deckery Mason, a post-certified, Peace Officer Standards and Training Council, police officer employed by Kennesaw State University. It was dark and raining, and Mason was on his way back to the university after delivering another arrestee to the Cobb County Jail when he noticed Zielke severely failing to maintain lane and driving without his lights on. After stopping and approaching Zielke, Mason observed that Zielke smelled of alcohol, had bloodshot and watery eyes, and was unsteady on his feet. Zielke told him he had drunk 2 beers. At Mason's request, Zielke blew into an alco sensor, which registered positive for alcohol, at which time Mason arrested him. Zielke then submitted to a state-administered chemical breath test on the Intoxilyzer 5000, which revealed a blood alcohol level of 0.08%. In Georgia, the definition of legally intoxicated is a blood alcohol concentration of 0.08% or higher for those who are at least 21 and driving a regular passenger vehicle. Zielke was charged with 2 counts of DUI, failing to maintain lane, and operating a vehicle without headlights. Zielke's attorney filed a motion to suppress the breath test when the case goes to trial, arguing that the officer had lacked jurisdiction to make the arrest, as the offense had not occurred on, or even near, the university's property. The trial court granted Zielke's motion, based on Georgia Code 20-3-72, which states, "The campus policemen and other security personnel of the university system who are regular employees of the system shall have the power to make arrests for offenses committed upon any property under the jurisdiction of the Board of Regents and for offenses committed upon any public or private property within 500 yards or any property under the jurisdiction of the Board." However, on appeal, the Court of Appeals reversed the decision suppressing the evidence, citing another statute in the Georgia Code, 17-4-23, which states that a law enforcement officer may arrest a person accused of violating any law or ordinance governing the operation of motor vehicles by the issuance of a citation, provided that the offense is committed in his presence, the arresting officer shall issue to such person a citation which shall enumerate the specific charges against the person and the date upon which the person is to appear and answer the charges. The Court of Appeals ruled that this statute applied in Zielke's case, as the traffic violation occurred in the presence of the arresting officer. Relying on its 1984 decision in Glasner v. State, the appellate court ruled that under 17-4-23, a post-certified campus police officer is authorized to make arrests for traffic offenses committed in his presence, even outside the territorial limits of the campus. Zielke then appealed the Court of Appeals ruling to the state Supreme Court. With today's decision, the High Court has overruled Glasner and subsequent rulings based on Glasner to the extent they hold that 17-4-23, authorizes any law enforcement officer, including a campus police officer, to make an arrest and take the person into custody outside the jurisdiction of the law enforcement agency by which he is employed. We agree that Officer Mason had no authority to effect a custodial arrest of appellant outside the jurisdiction conferred by 20-3-72, today's opinion says. But he also lacked authority under 17-4-23, the opinion says. First, by its plain terms, 17-4-23, which is a criminal procedure statute, only authorizes an arrest by the issuance of a citation, the opinion says. The statute does not confer the ability to make a custodial arrest for a motor vehicle violation, unless that person fails to answer the citation by appearing in court, and then, any apprehension of the person must be made pursuant to a warrant. Indeed, the purpose of 17-4-23 has never been to enlarge the territorial boundaries of the various law enforcement agencies in the state, but rather to give law enforcement officers the discretion to write a citation in lieu of making a custodial arrest for motor vehicle violations. Therefore, the trial court did not err when it determined that Officer Mason did not have any authority to arrest appellant beyond 500 yards of the Kennesaw State University campus, the opinion says. However, the court notes that suppression of evidence is an extreme sanction that is used only sparingly as a remedy for unlawful government conduct. When there is a violation of a statute, the suppression of evidence is an appropriate sanction only where the statute specifically provides for suppression as a remedy or the statutory violation implicates underlying constitutional rights such as the right to be free from unreasonable search and seizure, the opinion says. However, on appeal, the state did not challenge the court's suppression of evidence as error, nor did the trial court identify the legal ground on which it was excluding the evidence as a result of Mason violating 20-3-72. Therefore, that aspect of the trial court's order is not before the Supreme Court for review. In a concurrence, Justice David Namaez writes to emphasize that excluding evidence may not even be an authorized remedy for such a violation, and there is a substantial question regarding whether it was proper for the trial court to suppress evidence as a remedy for the violation of 20-3-72 that the court correctly found in this case. The concurrence, joined by Justice Keith Blackwell, concludes that this discussion should highlight the importance of considering the remedial element of motions to suppress evidence in future cases of this sort. Attorney for appellant, Zielke David Willingham of the Willingham Law Firm, P.C., and Bimal Chopda and Stephen Cook. Attorneys for appellees, State Barry Morgan, Solicitor General, Deborah Tatum, DEP Chief Assistant Solicitor General, and Mimi Scalgian, Assistant Solicitor General.